This is part 3 of civil procedures, looking at venue. Change of venue when original venue is proper can be transferred to any district that it could have been brought originally, or any district the parties consent to. If jurisdiction is based off of diversity, the court transferred to must apply the law of the court transferred from. If it's federal question jurisdiction, the court that it is transferred to must apply the federal law of the appellate court in that district. Original jurisdiction proper, diversity, apply the state law of the state it came from. Federal question, apply the law of the jurisdiction it goes to. Venue change when original venue is improper. You must dismiss, or you may transfer it to any district which it could have been brought originally. In a diversity case, apply the law of the state of the district it's transferred to. It's a federal question. Again, the law of the jurisdiction it's transferred to, because the original jurisdiction was improper. Looking at choice of law in the Erie Doctrine. If the court has federal question jurisdiction, you apply the federal substantive and or procedural law. If the court has diversity jurisdiction, you apply the substantive law of the state and federal procedural law, even if the procedural law is in direct conflict with state procedural law. If there is no federal law, apply state substantive law. You may ignore state procedural law. Okay, choice of law in the Erie Doctrine, an analytical approach. Where there is no conflict in law, there's no issue. Where there is a conflict between federal and state, where there is conflict, if there is a valid federal statute, you apply federal law. If no valid federal statute, decide between federal common law or state law. Use federal common law if it would not provide a different outcome, but if different outcomes likely, then apply the state law. Choice of law, the Erie Doctrine, and applicable state law. Federal courts are bound by state Supreme Court rulings when applying state law. If not yet ruled or spoken upon, you can view the lower court cases and determine how the state Supreme Court would rule. If the state Supreme Court rules differently after the case, and the federal appeals court must apply the new ruling. Looking at pleadings and time computation, computating time and pleadings includes Saturdays and Sundays. If it ends on a Saturday, Sunday, or holiday, it extends to the next non-weekend holiday day. Time computations for motions, hearings, affidavits, they must be served at least 14 days prior to the hearings, motions, or affidavits. Service of process, you have 120 days to provide service of process after filing of the complaint. These methods may be individual, which is personal, leaving summons and complaint at the defendant's usual place of abode, delivering summons and complaint to an agent. If it's a corporation, the summons and complaint may be delivered to an officer and or agent. You have a duty to waive service, and a court may impose service costs on the defendant for failure to waive. Looking at injunctions, there's a mandatory injunction where the defendant must perform an act. Prohibitory injunction prevents D from performing an act. Generally, the complaint if the complaint requires conditions precedent for, such as a contract action, you have to plead conditions precedent. If you want to just plead that all occurred, this can be generally alleged. If you want to plead that one didn't, that must be pled with particularity. In regards to special damages, they must be specifically claimed. You have 21 days to respond to a complaint. And that concludes part 3 of civil procedures.